Hi, my name's Faye and I'm a director at Harris & Clarke Chartered Surveyors. Today in this video we're going to be talking about what a party wall award is. We often get inquiries from building owners saying, I need a party wall agreement, can you help? And the answer is yes. But first let's clarify some things. That agreement is formally known as a party wall award. A party wall award is a legal document prepared by either one agreed surveyor acting for both parties or two separate surveyors, one for each party. Its purpose is to resolve any disputes that arise when a neighbour, known as the adjoining owner, dissents to a party wall notice. Here's the good news, you might not need an award at all. If your neighbour consents to the notice, then there's no dispute and no award required. Are you curious about party wall notices? Well, check out our helpful video on our YouTube channel or visit our website for more information. So, do you always need a party wall award? Not necessarily. A party wall award isn't required for both parties to enjoy the rights and protections of the Party Wall, etc. Act 1996. What is essential is that the building owner serves a valid party wall notice. There's a common misconception that neighbours are only protected if an award is in place, but protection under the Act begins as soon as a valid notice is served. What does the Party Wall Award include? A Party Wall Award typically contains three key components. The award itself, which outlines how the works must be carried out. A photographic schedule of condition, documenting the condition of the neighbour's property before work begins, supported by photographs and written descriptions. And drawings, detailing the proposed notifiable works which are covered by the Act. What are some of the key details covered in a Party Wall Award? An award is commonly based on a standardised document, which is then amended and modified to meet the details of the proposed notifiable works. While there is no prescribed format for an award, you will usually see the following details included within it. It will clearly state the details of the two parties, for example, the addresses of the properties, the owners of those properties, and the owner's home or correspondence address. It will also include the details of the surveyors who have produced the award. This could be an agreed surveyor, or the two surveyors and the third surveyor. If an agreed surveyor has produced the award, there will not be a third surveyor. The award may also include other details such as details of the proposed notifiable works, working hours, whether working at weekends is acceptable, access arrangements, security arrangements, method statements, protection measures for any exposed party walls, a time limit for the building owner to commence works, costs and who should pay them and when. But there can be much more. How are awards enforced? To be able to enforce an award, the award will need to be deemed valid. A valid award creates legal obligations between the parties. If a party breaches the terms of the award, this will create a legal liability, which can form the basis for court action by an aggrieved party. A successful action in the courts would result in a court judgment, which could then be enforced against a defaulting party in the normal way. The award is for the benefit of the owners. So in the event of a breach of the award, it is for the owners to take enforcement proceedings. Surveyors will always recommend that their appointing owners obtain legal advice if they intend to enforce any part of an award. The Party Wall, etc. Act aims to keep disputes out of the courts. We often find that disputes are often best resolved between neighbours and that solutions can be achieved without needing legal action. If necessary, your surveyor should be able to help you understand this. What if I do not agree with the award? Once a Party Wall award has been served on you, you will have 14 days to appeal the awards through the county court. However, we recommend that you proceed with caution and in the first instance speak to your surveyor about your concerns. Thousands of Party Wall awards are made each year, and only a few hundred awards are appealed, with only a handful of those making it to a final hearing. There are limited published cases, and it can therefore be difficult to decide whether it is appropriate to appeal your award with little to compare it to. If you appeal the award, you face litigation and cost risk. Appealing an award is classed as contentious litigation, meaning that one party will win and one party will lose, and it is often the unsuccessful party which will pay the majority of the associated costs. These costs can run into the tens of thousands of pounds, and you may not end up with the result you want. Appeals can also take many months to get to the final hearing, meaning that your neighbour may have already completed the works, and you might undergo quite a lot of stress. You should not take an appeal lightly. If you really are concerned about the contents of the award, you should seek sound legal advice before taking action. Often, the party wall surveyors may be able to resolve the issue without appealing the award in the first place. So the first step is always to approach your surveyor and have a chat about your concerns. We understand that this brief video will almost certainly not answer all your questions about party wall awards. However, our experienced team of surveyors will be more than happy to chat with you about your concerns and answer any questions that you might have. They can be contacted on 023 8155 0051.